Hello everybody, and welcome to Taylor Wessing's Brexit and Brands update. My name is Roland Mallinson and I'm here with a colleague, Louise Popple, and we have a busy amount to run through today. I have an agenda, if I just get on to the next slide, where you can see there. Now, those of you who have been following our publications on this, what we're doing today is an update from our 26th of September update, which was reporting on the situation where there might be a no-deal outcome on Brexit, and in particular was referring to various UK government technical notes that have been published in the month running up to that report. Since then, we've had a busy period. There's been a draft withdrawal agreement weighing in at a mere 585 pages. That itself was an expansion on the draft agreement from the 19th of March, which was a mere 100 or so pages. But now it has all its annexes, and that was dated on the 14th of November and signed by the Commission and the UK government on the 25th of November. We then also had, as of literally last Friday, the publication by the UK government of the draft EU exit regulations for trade, relating to trademarks and covering a no-deal situation. So we're going to update you on all that. Of course, we still don't know precisely where we're going with the withdrawal agreement. In truth, a lot has happened since I had this little piece of paper sent to me through the post in June 2016, which I happened to find still inside my suit pocket only a few months ago. Now, the timeline, as I say, has been busy. This is an outline of what we've had to date and also what we have to come. And you'll see under the 2018 date that in the 11th of December, in a few days' time, 5 days' time, we have an important vote in the UK House of Parliament on whether the draft withdrawal agreement is being accepted or not. And you can see there that there is also a timeline for what happens if that vote is not successful for the government. There's 21 days for them to put up some alternative, but no one knows quite what that alternative would be. The European Parliament also gets to vote on this, perhaps towards the end of this year or the beginning of next. Essentially, if there is no deal, we will be leaving the EU on the 30th of March at 11 p.m. UK time, 12 midnight in the EU. But if there is a withdrawal agreement and a transitional period, that would then end instead on the 31st of December 2020. With the possibility of that being extended by up to 2 years with a single one-off extension. So we have our transition period there possibly. Equally, we might have our cliff edge scenario. So we do have 4 Brexit scenarios we need to contemplate. The first, to some extent, made seemingly more possible. Maybe as of today, we had an Advocate General's decision in a litigation brought by various members of Parliament that has now told us, at least in an Advocate General's opinion, that the UK government can simply rescind Article 50 as long as it does so before exit day. This, of course, is only an opinion, and we are awaiting now the Court of Justice decision. The UK government argued against this, and so indeed the EU. The UK government's position was simply that is not on the cards, and there is no proposal for us to withdraw the Article 50 notification. But nevertheless, this has created possibly what some see as a small window of opportunity to reverse Brexit. Otherwise, we have a deal scenario to contemplate, which is based on the draft withdrawal agreement, the 585-page document I refer to, and that would allow transition to the end of 2020 and possibly to the end of 2022. And essentially that would be business as usual. So your trademarks and designs would be subject to exactly the same protection as they have currently and would be enforceable in the same way as they are currently. We are going to consider later in this presentation issues of pan-EU rights in the UK and pan-EU rights in the EU 27 countries, both in this deal scenario and in the no-deal scenario. And various documents are going to be relevant to this discussion we're about to have, the primary ones being the withdrawal agreement itself. There is also a document that was issued in January this year, which was a Q&A document, a question and answers document issued by the EU IPO, and that was also trying to address a no-deal scenario. And those questions and those responses will give some guidance on where things will go. And in addition, I mentioned the new, well, only draft at the moment, Trademark Amendment EU exit regulations that were published only last Friday. So those will feed into the no-deal scenario in particular. And then the final one at the bottom there, you'll see there's a deal other. No one knows if that's a possibility. Some say there is an option. There may be an option to try and defer the end of the end of the 30th of March deadline, move it on a few months, and see if something else can be agreed. But of course, lots of people say that's not a possibility. So we don't know where we are on that particular situation. But just to make it simple for our scenario today, we're going to look at these only two of those scenarios, the no deal and the deal basis, and the deal basis essentially bearing in mind the draft agreement that is before Parliament now. And again, in each of those scenarios, we need to look at the situation of what happens to the existing pan-EU rights or pending rights, both in the UK and in the EU 27 countries before and after the exit day. And you can see there the documents that effectively we're relying on. And in addition, actually, the withdrawal agreement, of course, has an impact in the deal scenario in the EU as well, of course. So the easiest way of doing this is tabulating it, we felt, and just running through some scenarios. This looks at a no-deal Brexit and a deal Brexit. I'm not going to run through every point here because some of this is a repeat of our previous webinar, which we touched on this back in June, and indeed publications we've put out certainly since March when we had the draft withdrawal agreement in our hands. But a new point to bear in mind here, under the no-deal scenario, this one arises under the EU exit regulations published on Friday. It seems that we will be providing, the UK government will be providing the possibility for an opt-out for having your EU trademarks that are registered pre-exit. You can opt out of them being turned into a comparable UK right. There's no such opt-out being mentioned in the deal scenario, so that isn't mentioned in the draft withdrawal agreement. But in reality, it's not particularly exciting because, indeed, if you have a UK comparable right created upon exit, it's perfectly within your liberty simply to surrender it. And surrendering your new UK comparable right would indeed amount to the same of opting out, really. So nothing too significant there. EU applications, no real change there. This is exactly as we were seeing and expecting since at least March. If your application is pending, your EU application is pending on exit date, then you will get the opportunity to refile in the UK if you wish, and you can backdate that application to the date of filing the original EU TM. This is some significance in particular for applications that have been pending for more than 6 months, and in some cases, of course, some applications have been pending for many years. I'm certainly aware of one that's been pending for at least 4 years, I think. Now, what will happen in that scenario, if it's still pending as at exit date, then that can be refiled in the UK, and the priority of filing date will be treated as the original filing date and priority date of the EU TM. So that could mean you end up with a new UK application backdated up to, say, 4 years perhaps. And that is definitely something that has a bearing on the strategy that one might want to consider going forward. Internationals, we don't know quite where we are with internationals. The UK government needs to progress discussions with the WIPO, and that has yet to be reported on. There are two areas where there's a seeming lack of reciprocity in the arrangements that have been agreed or provisionally agreed between the UK and the EU 27 member states. And these arise under the use situation, the scenarios, and the reputation situation. So there we have a situation where seemingly in a no-deal Brexit, we'll have pre-exit use of an EU TM anywhere in the EU will count as use of the comparable UK TM post-exit. And yet it's unclear whether the pre-exit use in the UK will enable you to defend your subsequent EU 27 post-exit. That has yet to be decided. And then likewise, on a reputation basis, you could have a situation, as we understand in the draft regulations out on Friday, where you are in a position to rely on a reputed trademark in the UK post-exit, but where that reputation isn't in the UK. That reputation actually was in Italy or Spain, for example. And this is a UK comparable right split out of a EU TM, and it only had a reputation in Italy or Spain. But nevertheless, according to the draft regulations, you're going to be in a position to get extended protection in the UK, relying on that reputation in Italy and Spain. It's a curious one, but in reality will probably have not a lot of impact, because it will be extremely difficult to show the mental link to succeed with an extended protection assertion in the UK if no one in the UK has ever heard of that brand. In reverse, it seems almost certain, but we don't know, that a reputation for the EU TM that had a reputation only in the UK, it seems unlikely that that reputation could then be relied upon in the EU 27 going forward. And I think it's worth bearing in mind also, under the deals scenarios that we have in the draft withdrawal agreement, there's also no revocation of a comparable UK trademark on the basis that the corresponding EU trademark was not used in the UK pre-Brexit. There's some uncertainty as to what exactly that means, and we will address this a little later. So, continuing with our comparison, let's look at attacks on EU TMs, and these could have been filed pre-exit or post-exit, and in particular it needs to be borne in mind whether the decision is pre-exit or post-exit. And what we do know from the Q&A answers from the EU IPO was that in the EU 27 countries, the approach will be taken that once the UK has left the EU, essentially the rights in the UK will be of no relevance. Any prior right in the UK will be of no relevance, even if that prior right was a valid prior right, as at the time the later EU TM was applied for. This is somewhat in conflict with the legal analysis that would be made in the UK, but nevertheless that's the position we're told will be applied, and it is also unclear whether only absolute grounds for invalidity or revocation in existence at the decision date will be relevant there. So it's really a question if absolute ground objections only arise in the UK. We're not quite clear how that will apply as against EU TMs going forward. Results of a post-EU TM invalidity or revocation decision also will not affect comparable UK TM, and that's in the no-deal Brexit. And yet, in contrast, results of a pending EU TM invalidity or revocation action decided post-exit will apply to a UK comparable right. So that means the UK comparable right would then be removed or cancelled under the withdrawal agreement that we've got at the moment. Other provisions that are new here that are worth drawing upon, highlighting here, attacks on UK trademarks. So where a prior EU trademark is filed pre-exit, it's probably still going to be taken into account in an attack against a later UK trademark. So that's been now confirmed in our draft regulations that came out on Friday. Obviously important to bear in mind lower down in the infringement on the UK courts is that the UK court in a no-deal Brexit will not be taking into account ECJ rulings, and in a deal Brexit they will be if the referral has been made before exit. And so you can have a situation where a post-exit ruling will be applied in the UK courts after exit, and that's borne out in the draft withdrawal agreement. What else have we got here? Infringement decisions. The UK will recognise existing injunctions unless the court order otherwise. That came out in the draft regulations on Friday, and that is something new to us, but probably to be expected. We're expecting the same actually in the deal scenario. So we've now completed looking at the comparison of the two scenarios. We're going to look at the filing situation here. So moving our slides on.
Thanks, Roland. So what we're going to consider in the following few slides, as Roland said, is what all this means in practice. Firstly, in terms of brand owners' filing strategies, and then in terms of their dispute strategies. And we're going to assume that there's a no-deal Brexit and that the UK is out at the end of March next year, as that's obviously more pressing. But we'll point out later when the strategy might be different under the deal Brexit scenario. So obviously the end of March will be quickly upon us, but there is still time to take action to strengthen your position. So looking at whether you should refile any marks, well, firstly, as far as EU trademark registrations are concerned, there's no need to refile them in the UK. As Roland has said, they will automatically be protected as comparable UK trademark registrations with no loss of filing and priority dates, so there's no need to do anything new there. For EU trademark applications that are currently pending, so this is our point 3, for the same reason, there is no need to refile them if in the UK, if they're going to register by exit. You'll automatically get that comparable UK trademark registration. And for that reason, applicants for EU trademarks should now be trying to prosecute their EU trademark applications as quickly as possible. Delaying, even on minor issues like specification objections, could mean the difference between getting a UK trademark registration and merely the right to apply for a mark in the UK. But if you can't do that and your EU trademark won't register by exit, there's still no general need to refile a separate UK trademark application. As Roland said, you're going to get a 9-month priority period in which you can file for the same mark in the UK, and you'll get the benefit of the EU trademark priority or filing date. Having said that, if UK protection is required urgently, perhaps for licensing or enforcement purposes, and you're not concerned about retaining the priority or filing date of the parent EU trademark, then you could refile now instead. We do expect there to be delays during that 9-month priority period, which may kick in next year. There are 86,000 pending EU trademarks at the moment, and even if a fraction of those are refiled in the UK, then the UK IPO is going to be very busy. So if you do want protection quickly, then you might consider refiling now, but bear in mind that you will lose that priority or filing date of your parent EU trademark, and also obviously the application costs will be wasted if in fact there's a deal Brexit and your EU trademark registers in the interim. So that's for, let me forward? Yes. So that's the position for pending EU trademarks. What about EU trademarks that you're about to file now? Well, they are unlikely to register by next March, even if they're filed now on the fast track. But again, no need necessarily to refile those at UK level. At UK level, you are, as we said, going to get the right to refile in the UK anyway, and so it's the same situation as I just explained. If you want UK protection quickly, you might refile, but bear in mind that the application costs might be wasted if we don't drop out of the EU next March. Just a few other things to think about in terms of filings. Firstly, and this is point 5, what if your EU trademark is more than 5 years old and has only been used on the continent up to Brexit? Should you refile that mark in the UK to get a fresh 5-year period? Well, as Roland's already said, there's no need to do that. Any use that has been made of the EU trademark in the EU pre-exit will be ported across to the comparable UK trademark, so there's no real additional need to refile in the UK. However, again, as Roland said, the position is a little more difficult if there's an EU trademark that has only been used in the UK, because there the EU IPO has said that that use might not port across, and only a decision of the CJEU will ultimately decide that. So for a belt and braces approach, where you have an EU trademark that's more than 5 years old and which has only been used in the UK pre-exit, you might consider refiling that in the EU now to get you another 5-year grace period. And then just one final point. If you've got an EU trademark pending on exit and there are absolute grounds of objection that relate to the UK only, perhaps the EU trademark is non-distinctive in the UK for some reason, but it's distinctive elsewhere, then there is a chance that those grounds, those absolute grounds, will be ignored post-exit. And that's even though they were relevant when the EU trademark was filed. Unfortunately, the EU IPO guidance that has been issued is silent on this point today, so we just don't know how that's going to be dealt with. But you can imagine If the EU IPO has said that it's going to ignore prior UK trademarks, then you can also imagine them ignoring prior absolute grounds that relate to the UK only. So what you might find in this scenario is that some EU trademarks that are pending at exit might register post-exit when we weren't expecting that to happen.
Thank you, Louise. So now we thought we'd consider look at some scenarios in pending disputes that are pending now or about to be filed, and really what's the strategy you should be taking now in light of Brexit. Well, as a general rule, I think it's fair to say that prior rights holders will generally want to hurry up, and essentially the later user or right holder will probably want to delay things. But that is very much a general rule. And the situation is certainly more complex if there are infringement proceedings contemplated or afoot, particularly where the EUTM is being relied on, and that EUTM is or could be the subject of an attack. It then becomes certainly needs to be considered on a case-by-case basis whether you're going to be wanting to rush things along or slow things down. And actually, it's almost best to look at some examples, but you'll see in the EU IPO opposition scenario that we've got here at point 2 that typically the EU applicant will want to try and get that concluded before exit day so that they can then end up with an EUTM that's granted and in existence as at exit day, and thereby will get a free comparable UK trademark on the back of that. But there are circumstances where they wouldn't necessarily wish to do that if there is a plausible prior right, but it's only based in the UK or it's based on reputation in the UK. In that scenario, of course, if the decision is rushed through pre-exit, then the outcome would be that the EUTM application fails, is rejected. It can be converted, of course, but then you've got a conversion in many, and perhaps possibly all member states, whereas you've lost your EUTM. If, of course, you've delayed matters until after exit date and a decision is post-exit date, then you have a situation where the UK prior right may, seemingly according to the Q&A from the Commission, the EU IPO, the UK prior right will be ignored. Even though it was valid at the date of application, it will be ignored because it was no longer relevant to the EU27. In that scenario, the EUTM survives. And you would also have a situation where your pending EUTM can be split out into a comparable UK application with the benefit of 9 months within which to file and claim priority. So there are scenarios where one wouldn't, as the applicant and the prior right owner, necessarily want to see your decision rushed through. The examples here may help to illustrate this. So we've got a prior right here for where the UK prior right is in a repos. It's in the UK only. It's opposing an EUTM. Here, the applicant, EUTM applicant, probably would want to delay matters because the UK-only right would potentially be disregarded post-exit. If, in a similar scenario, if the prior right was instead of a UK right an EUTM right, but based only on, and the chance of succeeding the opposition was extended protection, then the reputation in the UK only would be somewhat similar to there being only a UK prior right. Again, the EUTM applicant would actually want to delay matters and try and get a decision post-Brexit. There's some similarities in invalidity and revocations which I'll look at. It's probably easiest done, again, looking at examples here. So if we look at our examples here, we've got a mark subject to invalidity, EUTM, registration for the word fresh. It's being cancelled, or there's an application to cancel it based on a prior right UK registration for frish. Here, the EUTM owner will again want to try and delay things because it will want to have a situation where the decision is post-exit, and the argument can be made that the earlier UK right should then be ignored. Similarly, if the EUTM is being opposed on the basis of a French registration for frish, then the EUTM owner there would preferably want to wait and have the decision post-exit because then they will have a UK comparable right split out rather than actually merely a converted right which starts afresh with a UK application. So ideally you want to still have yourself with a registration on exit day. The fact that it's subject to a pending attack on exit day doesn't then mean that the comparable right doesn't arise. So if we then look at the revocation scenario, you'll see some sort of similarities here. But here, if we consider the situation where the allegation is that the EUTM for the right hollow is now no longer valid because it's become a common trade name in the UK, common name in the UK. If the EUTM owner manages to delay the decision until after exit, then this basis of challenge may be disregarded under the EU IPO's approach as published in January. Likewise, if the basis of the attack is that there's no genuine use is only sufficient in the UK but not elsewhere, then again we might end up with a situation where that use in the UK is disregarded, and therefore the EUTM can be sustained. Where the EUTM is being revoked, but there has been genuine use in the UK sufficient to maintain a comparable UK but not an EUTM, the EUTM owner will want to delay to get a comparable UK trademark registration, whereas otherwise it would just get the conversion right that we had in our invalidity action scenario. Here we're looking at oppositions at the UK IPO based on prior EUTMs. And if we look at our example, again, the easiest way of doing this, so the mark being opposed is a UK TM. This is for Repassa on this occasion. It's being opposed on the basis of a prior right and EUTM for Repos. That prior right is more than 5 years old and has only been used in Germany and France, so it's not been used in the UK. Here you'll have a situation where the prior right owner will be taken into account in the UK opposition because it will have been a valid right as at the date of application of the UK. And the pre-exit use in France and Germany will be counted towards the validity of that EUTM. So the fact that it hasn't been used in the UK will not mean that it cannot be relied upon in that opposition. Scenario 6 we're looking at here, UTM infringements in the UK court. So this is now infringements. Of course, we're still in a no-deal scenario, so post-exit, the UK court will simply be unable to decide on infringements outside the UK. It can't grant pan-EU injunctions, and it can't invalidate or revoke any EUTMs that are put in issue before it. So it does mean if you've got a pending action, and it has to be now quite advanced really, to get yourself your pan-EU injunction before exit, if there's a no-deal scenario. And that way, having obtained a pan-EU injunction in the UK court, it will then be valid and enforceable around the EU still post-exit. Bear in mind, if you haven't yet started your action, or if in fact you have an action already pending against the defendant, and the defendant is based in the UK, and you're seeking a pan-EU injunction, you won't be able to get your pan-EU injunction after exit day. And so what you will want to then consider is waiting until exit day and then suing the defendant. You would then have a choice of suing either where you're domiciled, if you're a UK EU-based entity, or if you're also not an EU-based entity, then neither the defendant nor the claimant is an EU-based entity, and they will be suing in Alicante, which is the seat of the EU IPO. But there, at least, you could obtain a pan-EU injunction post-exit on the basis of the EU27 that you've got, right that you've got. Largely, and as a generalism, the defendants are therefore going to be wanting to drag things out in these scenarios and try and ensure that no final decision is rendered until after exit day. But there is very much a complication that arises if the EUTM is under attack or could be made under attack. Bear in mind the UK court, and these are rules now arising from the regulations we had published on Friday, the UK court will be considering the infringement of the EUTM in the UK, and they will also consider an invalidity or revocation of the EUTM. They can't actually cancel or revoke it, but they will effectively say that there's no enforceable right in the UK arising out of it, and they can obviously cancel or revoke the EU comparable right that comes out. So all of those can be put in issue. One point that is interesting that's come out of Friday's draft regulations is that the UK court will be taking into account Article, I think it's 122, and around there, Chapter 10 of the Trademark Regulation, and that's the regulation that tries to deal with situations of avoiding conflicting judgments around the EU. Now, what it has said is that they will take all that Chapter 10 into account, but it will not allow a stay or allow an assertion of estoppel where there have been potentially conflicting decisions elsewhere in the EU. Now, this is interesting because it does mean that in the UK court you would be in a position to rerun validity arguments and revocation arguments that may have been finally decided outside the EU, because the court, the draft regulations make it clear that those points of estoppel and stays will not be recognised by the English court. So we have a situation with EU team infringement in other member states' courts. This is largely, I think, as one would expect. So outside, you would then be suing in the EU 27 countries. You'd be relying on your EU 27 right. And of course, the EU 27 countries, the community court, could no longer render a judgment or an injunction that bites on the UK. And so claimants obviously should try and get those sort of injunctions rendered before the 29th of March or whenever we have exit day. Likewise, the defendants will want to try and drag that out. There is a strategy that will depend on whether or not that EUTM is under attack. And there is an oddity to some extent arising out of certainly the EU IPO's interpretation of whether UK rights should be ignored post-exit. So you could end up with a situation where you're suing someone, say in France, on an EUTM right now. It's being counterattacked for invalidity, and the counterattack is on the basis of a prior UK right. Now that prior UK right is valid now, and one might, and maybe it's got a strong ground for challenging the validity of the EUTM. Maybe it could actually have it cancelled now. But unfortunately for the defendant, the decision is rendered post-exit. And there, the situation seems to be, and it will be subject to the national court interpretation, and maybe ultimately the CJAU, but the situation could be that the national court would no longer take into account the existence of the prior UK right. In that situation, the EUTM is valid, and the defendant is then infringing, and his defence has gone out the window. So that could well be unfortunate, and is another reason why you can imagine a defendant, therefore, would probably want to bring that case as fast forward as possible. So we do have a situation where whether the right is being challenged will impact on the strategy that either a claimant or a defendant will be taking. Will be taking in this. So, of course, all of this is a no-deal scenario. Any actions that started right now on the basis of strategies that we're considering here could end up being entirely unnecessary and wasted costs if we have a deal. And there you might want to see what's happening in the next 5 days. So, looking ahead, Louise will take us forward for what you might be doing next year.
Yeah, so Roland's looked there at the strategy for a no-deal Brexit scenario, and we're not going to look in the same amount of detail at what's going to happen if there's a deal Brexit, because I think it would probably be too much for today. And actually, for the most part, the strategy is going to be the same whether there's a deal or no deal Brexit. It's just when, in terms of the date that we're looking at it. Having said that, there are two areas where the strategy will vary quite considerably between a deal and no deal scenario, and we just wanted to take you through those now. So the first is in a deal Brexit scenario, the fate of the comparable UK trademark registration is to some extent tied to the fate of the EU trademark from which it derives, and that's because it says in the withdrawal agreement that if an EU trademark is invalidated or revoked as a result of proceedings pending on exit, the comparable UK trademark registration will also be invalidated and revoked unless the grounds for invalidity or revocation do not apply to the UK. Whereas under the no-deal Brexit scenario, obviously your comparable UK trademark stands on its own, and you would need separate invalidity or revocation proceedings in the UK if you wanted to knock it out. So you can expect in the deal Brexit scenario, you can expect a lot of arguments about whether the grounds for invalidity revocation apply in the UK or not? An example could be where an EU trademark is perhaps non-distinctive in somewhere like France, and so the EU trademark would fall, but the mark is distinctive in the UK, and so the comparable UK trademark wouldn't fall. So the net result of all that in terms of strategy is that it's not always going to benefit the EU trademark owner to delay the proceedings in the way described by Roland, because in fact the fates of these two marks are intertwined. And actually the strategy you want to adopt will vary depending on the factual matrix, and it's probably quite complicated and probably beyond the scope of this talk to go into that now. The second area of difference is around the use requirements for the comparable UK trademark registration. And here an issue arises because the wording under the withdrawal agreement and under the UK regulations which came out on Friday is subtly different. So under the no-deal Brexit scenario, so this is the regulations from Friday, pre-exit use of an EU trademark anywhere in the EU counts as use of the comparable UK trademark post-Brexit. So the necessary conclusion from that is that the owner of the comparable UK trademark will get 5 years from when the EU trademark was last used in the EU to use his mark in the UK, assuming he's never used his mark in the UK at all. However, the wording, as I said, is subtly different under the withdrawal agreement. So this is the deal Brexit scenario. Here, the withdrawal agreement says that there can be no revocation of the comparable UK trademark just because it has not been used in the UK pre-exit. Now, it's not quite clear what that means or how that wording will be implemented in UK law, because of course the withdrawal agreement will need to be implemented here. But one possible interpretation is that the comparable UK trademark gets a fresh 5-year grace period from the date of exit. And if that interpretation is correct, then it's quite a significant difference. And it means that if you're aware of an EU trademark that is more than 5 years old and has not been used anywhere in the EU pre-exit, you should apply to revoke it before exit. And if you do that and you're successful, the EU trademark will fall down, and of course so will the comparable UK trademark because their fates are tied together. But if you don't institute those revocation proceedings pre-exit, then you will not be able to do so post-exit, because of course your comparable UK trademark then gets this fresh 5-year grace period for use. That's quite a significant difference there in terms of the wording.
It's worth adding there that these comparable UK rights are seemingly being created without there being any obligation for the applicant, the owner, to confirm that they had a genuine intention to use the trademark in the UK. And that then means that these comparable rights are not going to potentially be subject to a bad faith attack for no intention to use them. So as Louise points out, if you have a situation where these comparable rights are created, they've never been used possibly anywhere, they're long since revocable pre-exit, and then suddenly they get a 5-year new grace period, making them very difficult to challenge post-exit. So this could be a concern, I think, for those who can see these rights on the horizon and wish to consider challenging them before exit.
So you'll have seen from all of that there are still quite a few uncertainties, particularly around what the EU IPO and other EU member states courts are going to do post-exit. And unfortunately, I don't think we're going to get any extra clarity on that, because the EU IPO has indicated that only decisions of the ECJ will ultimately decide these issues, so we're not going to get any legislation from the EU side. So we've listed here some of the uncertainties, most of which we've already touched upon. So I'll just skip through these now. We don't know whether pre-exit use in the UK will count as use of the EU trademark post-exit. We think it will, but the EU IPO said that a decision of the CJEU will be required on that. Likewise, where the EU trademark has a reputation in the UK only, we don't know whether that reputation can be ported across to will be taken account post-exit for that EU trademark. The EU IPO's guidance on that is silent. We don't know whether prior UK rights are going to be taken into account in post-exit decisions. The EU IPO said that they won't, and that's consistent with their current practice. Likewise, we don't know whether absolute grounds of invalidity and revocation that apply in the UK only will be taken into account in post-exit decisions by the EU IPO. We don't know whether there's going to be any extra leniency in terms of if somebody attacking a later right wants to introduce additional prior rights. You can imagine a situation where if you're relying only on UK prior rights, you might want to introduce some other prior rights to bolster your position. We don't know if there's going to be greater leniency on that. We don't know what's going to happen in terms of international registrations, whether they'll, if they designate the EU, will they become plain UK rights, or will they still be protected as IRs but with the UK designation? And lastly, we don't know what the other EU member states' courts are going to do. Will they recognise pan-EU injunctions, for example, ordered by the UK courts? How will they interpret contractual documents that perhaps refer to the EU? Will they say that still includes the UK or not? If there is a deal Brexit, there might be scope for the UK and the EU to agree some additional things on IP. Nothing has been said on that, but we shouldn't assume that the withdrawal agreement is everything we're going to get. It could be that they agree some additional items. One can particularly imagine that there might be a desire on both parties to agree that pending litigation involving EU trademarks should continue across the EU if they're pending at exit, rather than the parties having to institute separate proceedings as a result of exit. Obviously, if that happens, then the UK courts would need continuing competence to refer questions to the CJEU and so on and so forth, and both the UK courts and other member states would have to agree to be bound by each other's decisions. There is scope for the parties to agree something on limitation periods, because quite clearly if you have a pending action in one court and as a result of Brexit you need to institute separate proceedings in a different member state, you could quite possibly be out of time. So this hasn't been considered as far as we're aware to date, but we feel that there is scope there for probably a need for some sort of agreement on limitation periods. And then all the things that I think have cropped up in previous talks, there's obviously going to need to be, well, we hope there's some sort of deal on rights of representation for UK professionals, on professional privilege, contract interpretations and exhaustion of rights and so on. So that kind of completes things in terms of kind of portfolio management and disputes, but we wanted to cover another couple of items. Firstly, parallel imports, and then secondly, IP-related agreements, because these are the questions that often crop up. So on the parallel imports front, we've actually got quite a good deal of information about what's going to happen as a result of Brexit. We know that rights that are exhausted pre-exit will remain exhausted both in the EU 27 and the UK after exit, and that's set out in the withdrawal agreement, and we expect the same position to be adopted if there's a no-deal Brexit. But what about goods that haven't been put on the market yet and are put on the market post-exit? Well, there's going to be a short-term interim measure if there's a no-deal Brexit in March, and that is set out in the Intellectual Property Exhaustion of Rights EU Exit Regulations 2018, and they're draft regulations which will be brought in if there's a no-deal Brexit. Under those regulations, the UK will continue with the current exhaustion regime. So that means that an IP owner can't use its UK IP rights to prevent goods that are first put on the market in the EU from circulating into the UK. And the reason the government's adopting that strategy is it's got a concern that goods should continue to be brought into the, shouldn't be prevented from being imported into the UK. And its particular concern is around things like pharmaceuticals, and obviously it wants to ensure that those continue to flow into the UK. The UK has said that it's currently considering all the options for how the regime should operate after this temporary fix, so that's a temporary measure, and it will consult in order to decide on the regime. So, what are the implications of this for this short-term stopgap that the UK has said it's going to implement? Well, it means that goods put on the market in the EU should be able to circulate into the UK, or at least IPR owners won't be able to prevent them from circulating into the UK on the basis of their IP rights. But because this is a unilateral measure from the UK only, the opposite might not be true. So, assuming the EU doesn't reciprocate on this, goods put on the market in the UK might not be able to circulate into the rest of the EU and EEA. Rights holders might be able to prevent that on the continent. So this is going to obviously benefit us in allowing goods to be imported from the EU into the UK for sale on the domestic market, but it's not going to be such a good deal for the many UK-based rights holders and distributors who are going to have to compete with imports from the EU on the domestic market, but are not necessarily going to be able to sell their own goods in the EU. So that's the interim measure, and going forward there's going to be this consultation, and we'll see what comes out in the wash there. So a lot has been said about the need to amend IP-related agreements in light of Brexit. But in fact, the regulations that came out on Friday for the no-deal scenario are quite helpful on this. And they say that any licence that is in existence at exit, which authorises the doing of acts in the UK which would otherwise infringe an EU trademark, continues to authorise those acts in the UK under the comparable UK trademark. So in other words, if you've authorised someone to do something in the UK based on your EU trademark, you can't sort of change the position or pull the rug out from under them just because you've now got a comparable UK trademark as opposed to an EU trademark. But all that is subject to the terms on which the licence is granted and any agreement to the contrary between the licensee and licensor, and it will apply with such modifications to the terms of the licence as are necessary for their application in the UK. But that's quite helpful, and you've got a similar provision where there's a consent rather than a licence, and a similar provision for security interests. In addition to that, there's a general catch-all which says that references to an existing EU trademark in any document made before exit day shall, unless there's evidence that the document was not intended to have effect in the UK, be read on and after exit days as including references to the comparable UK trademark as well. So all that is quite helpful. I don't think it means that you don't have to review your agreements, however. It's going to depend how they're drafted, particularly coexistence agreements. They're often not granted in terms of, or just in terms of consent. They often have clauses which prescribe what the parties won't do as well as what they will do, and it's possible that these provisions in the regulation won't catch that. So I think you still need to look at your agreements, but certainly there won't need to be as many amendments as perhaps we had thought. And then in terms of recordal, where a registrable transaction such as an assignment or a licence has been recorded against an EU trademark, unfortunately that recordal will not port across to the comparable UK trademark. So you will need to separately record that transaction against the comparable UK trademark when it comes into existence. you will have an additional period of time to do that if you have already recorded that particular interest against the corresponding EU trademark. But if you haven't already recorded it against the corresponding UK trademark, then you won't get any additional time. So you could find that some of these comparable UK trademarks that spring into existence, the time you're already out of time to record with the consequences that flow from that. So you need to get onto those recordals as soon as possible. And we expect that the position on this, on IP agreements, both in terms of these presumptions that I went through and the recordal strategy, is going to be the same if there's a deal Brexit as well. So, trying to bring all that together, because I know we've discussed a lot of things, here are our top tips. Firstly, try to get all of your EU trademarks registered before exit day. And the consequences of that is that you get a UK comparable trademark registration as opposed to this 9-month window when you've got the right to apply in the UK. Secondly, consider a separate UK application if your EU trademark won't register by exit and you need protection quickly in the UK, perhaps for licensing or enforcement, and there's no downside to any loss of that EU trademark priority or filing date. I think it goes without saying that you need to renew and maintain all of your UK rights now. They will become more important, so only let those go if they're clearly irrelevant to the business. Consider what advantages and disadvantages exist from accelerating or delaying your disputes, as Roland described. If you are attacking someone else's right, either in the UK or at the EU trademark level, make sure you rely on a mix of UK and non-UK rights because, as Roland said, your UK prior rights might be disregarded post-Brexit. Carefully consider your strategy for EU trademark infringement actions, and as Roland described, that can become quite complicated with knowing whether to sort of go for an action now or wait, so that needs some careful thought. Consider whether you can do get the business involved in any lobbying, for example, on the future parallel imports regime. I know that a number of clients are already thinking about that and what regime would suit them going forward, so think about if there's anything there you can do to influence the outcome. Review all of your agreements, particularly things like coexistence agreements, which might not be caught by these provisions in the regulations. Remember to record your assignments and licenses and security interests against the comparable UK trademark when it springs up. And finally, review your budgets. You're probably going to need to make 1 or 2 new trademark filings and possibly need some separate actions for invalidity and infringement. Just one point on that, do beware of any bogus letters you get asking for payments that are reportedly from the UK IPO. I know a lot of those letters go around. We expect there to be more of those letters on Brexit, so don't pay anything, make sure the business is aware not to pay anything unless it's official. And finally, look out for developments and clarifications because things will obviously change in the coming months. So to conclude, it's all going to come down to what the people inside this building decide next week. I think it's a week today when they vote on the withdrawal agreement, and we'll see what happens then. We will obviously let you know what happens, and we'll be continuing to issue updates. So look out for those, and obviously let us know if you're not on our e-alert distribution list, and we'll make sure that you still get those.
So thank you very much for listening, everyone. If I still have anyone listening at this stage, do send us through questions, and if we're unable to answer them right now, then we will be dealing with them happily by email. You've got our email addresses there. We won't pretend to know all the answers. There's an awful lot that's still up in the air, as you will appreciate. But as and when we know more, in particular after next week, and both the UK Parliament and the European Parliament vote. We'll see where we get to with the Court of Justice's decision on the potential reversal of Article 50. All of those are things to be watched out for and updated, not all of which will have an immediate impact on how you do things under your for your trademarks and designs, but certainly there's lots to be thinking about, and we hope we'll be able to help you with those. So thank you very much indeed for listening, and we'll hopefully be in contact next time there's an update.